becomes a barrier not only to the White House, but to his own very liberty. I want to bring in New York Times Magazine legal writer Emily Bazelon. Welcome back. Your thoughts on these speedy trials, all the above?
Well, it just seems as if there are all these planes that are lining up on the runway and they are trying to take off, and there are all these competing considerations. Trump obviously has an interest in delaying this as much as possible. For one thing, if he's elected president, he could try to make the federal charges go away. And also, you know, being under indictment is maybe not an asset with the voters, but actually having to go to trial, having these facts in the news every day is really not going to help him and will be an enormous distraction from campaigning. And so that's the dynamic. You have judges who want to move ahead. You have other defendants asking to move ahead very quickly with a trial date this October in a couple of cases. And then you have former President Trump trying to delay as much as he can. Yeah.
And then in Georgia, you see just how quickly things shift. Mark Meadows didn't just spend all that time and energy trying to duck the Jan 6 committee. He risked a lot of trouble over it. He was held in contempt for those, and we've reminded folks there were 4 people that faced those kind of contempt resolutions from the Congress. 2 were indicted, Navarro and Bannon. The other 2, Meadows and Scavino, were not, although he took that risk. As you know, Emily, and I want to remind viewers, all of that was about him basically saying 2 things. 1, he just didn't want to talk about it, which might be self-interest. And 2, at times claiming he couldn't talk about it, that there were legal bars to that. Well, all that went up in smoke. He talked about it in open court for 5 hours. And there may be aspects or parts of it he didn't get into, in all fairness. But he certainly could have taken that same approach with the Jan 6 committee. It took until yesterday. I want to read from some of his defense, which we now have for the first time, right? We didn't have that before. He talks about being on that infamous call with the Georgia elections official and says that it was really about trying to find a, quote, less litigious resolution of the Trump campaign's then pending lawsuit against the state. What do you think of this sudden change in his willingness or ability to testify?
You know, one of the things the legal process does is push people to speak the truth and to explain themselves because they're facing really serious consequences. And so I think what you're seeing here with Mark Meadows is that the incentives have realigned. Now he's trying to argue that he should be tried or his case should be heard in federal court because what he was doing were part of his official government duties, and that would give him the right to remove the case to federal court. There's a complicated question about whether if a judge rules in his favor on moving to federal court, that pulls all of the other 18 defendants in the Georgia case with Mr. Meadows into federal court. That's a really tricky issue. Meadows is trying to do the best he can because I think he thinks that will be a better jury pool for him and just a better venue. So one would think that these questions about whether he was pursuing his official duty or not, these are tricky issues. However, in trying to prove that's what he was doing, he provided a lot of details about these calls, about his involvement in them. And it's a sort of side effect of the more procedurally, the procedural aspects of the case that we're learning more about the substance.
Well, yeah. And what does it tell you about how many of these people strenuously insisted that they were defending principles of secrecy, separation of powers, and then suddenly, I guess, they're not?
Right. I mean, there's a kind of irony here that previously we were hearing all about how this was all privileged information. It was part of Meadows' duty as White House Chief of Staff, but he couldn't talk about that because of his confidentiality and his duties and his responsibility in that office. And now he is much more inclined to spill the beans because he has to provide some specifics to the judge to explain exactly under questioning exactly how all of these activities related to being the White House Chief of Staff, which still seems like a tricky question.
Yeah, as you say, there are nuances to that. To underscore as well the observation you draw, in all fairness, Mr. Meadows' interest in trying to move his trial to a different venue where he'll still go on trial obviously was enough for him to cough up this testimony, as you said. But this insurrection, which was waged against this government, this nation, if he cares to claim that he was on the right side of that, the honest, nonviolent government side and not the insurrection side, getting to the bottom of that apparently wasn't enough. That wasn't a good enough reason. I think that although everybody has moved their, standards and expectations lower, we shouldn't move them so low as to not note that and what that says quite clearly about him, someone who was taking an oath to uphold the Constitution, who was in that high position. We got a lot coming tonight, so Emily, thanks for being here.
Thanks for having me.
Appreciate it. What else is coming up? I could tell you, from the Grammys to Colbert, Jon Batiste, our special guest for a Mavericks interview tonight. That season has just begun, and he is one of our Mavericks. Also, we're going to look at this RICO charge and how it has led to 2 different outcomes in Georgia cases. A wider look at criminal justice that I want to share with you. But first, we turn to something completely different and very important to a lot of people's lives, how this president took this big step building on the Obamacare that he and his predecessor, well, one back, his former president, built together. We have that for you when we're back in 60